estate planning nightmares, avoiding costly mistakes that haunt families. Well, welcome everybody. Thanks for joining us. My name is Blinn, and we have some other folks at our office here on the call. We have Michael Fleshman is on with us, and we have Brett Green, attorney Brett Green. It's going to be chiming in and helping us out with some estate planning nightmare scenarios this morning. Michael, you want to introduce yourself?
Sure. I'm Michael Fleshman from Lincoln. Been here, I think next month will be the start of the 8th year here at Woods and Bates.
Time flies. Brett, you want to introduce yourself?
So I'm Brett Green. I'm newer to the Central Illinois area here, and I've been at Woods and Bates for over a year now.
Good. Thanks, guys. So here's an outline of what we hope to accomplish this morning. Introduce the panel. Check that off already. Then we have a brief primer, a brief reminder for some of what a will is versus what a trust is, what's the difference in those. Then we're going to go through 3 scenarios about beneficiaries or heirs, and we're going to then have some wrap-up information and some question and answer as necessary. So with that, I want to start with a little primer reminder of what is my estate. When we're talking about estate planning, what does that mean? What are we planning for? That type of thing. So someone's estate is real and personal property that they own at the time of their death, and those assets pass either to their heirs or beneficiaries, depending upon what kind of estate planning they've done. So when we're talking about estate planning, what I'm talking about is planning for your death or demise to ensure that your assets pass to appropriate people, appropriate entities, and we want to do that with the least amount of negative tax implications possible. So there's a couple ways we can do that. There's several ways we can do that, but the 2 that we're going to be talking about mainly are by way of last will and testament and trust. So last will and testament, or a will, is a document in which a person directs how their estate assets are going to be distributed when they die. The way that works is the will is deposited at the courthouse. The executor nominated in that document typically will file paperwork with the court to ask to be appointed. And that executor then is going to wind up the affairs of the deceased based on the marching instructions that are contained in the will. That will can do a lot of other things. One of the main things that we're going to cover today is talking about nominating a guardian of minor children. Okay, so that is one way we can do things. Another way we can do things is by way of trust. There's all kinds of different trusts, but the trusts, when we talk about trusts today, we're going to be talking about revocable living trusts. So that is a document or a trust agreement that's created during a person's lifetime. And what happens is assets and property are retitled into the name of the trust. That trust would appoint a trustee. Usually, in the trust that we're talking about, that's going to be the person that's creating the trust. We're still going to need a will in this situation. That's going to be normally a pour over will, which says I leave everything I own to my trust. And that's going to act as a safeguard to make sure everything gets where we want it to go. And if we do this appropriately and correctly, this type of planning is going to avoid that probate process I just talked about a minute ago. Okay, so there are pros and cons to each. If somebody does not have a planning document, they're known to have died intestate. So they've died without a will, and then their assets are going to pass according to the laws of the state of Illinois. Believe it or not, the state of Illinois is not the best estate planner ever, or tax planner. So here is a chart, just kind of pros and cons, differences briefly between a will-based plan and a trust-based plan. Will-based plan is a little bit cheaper to set up from the beginning, lower time commitment, but does not give any control of the assets if you're disabled during lifetime. On the other side of the chart there, when we're talking about a trust while we're living, it's a little higher upfront cost and time commitment to make sure that that trust is adequately funded. But that trustee or successor trustee, whatever the case may be, would have control of assets if you were to become disabled during your lifetime. And then we move into after death. In a will type plan, there would be the court involvement with the probate process. Again, the will would be admitted, executor appointed. There's a higher cost, more time consuming after death in a will-based plan. Could be delay to get the executor appointed depending on where you live. And there's no privacy with that process. Those records are public. It's a court record that anybody could look at. In a trust-based plan, there is not court involvement. I say this all with the assumption that we've done everything correctly, that the trust has been funded correctly, minimal cost at that point, minimal time commitment, no delay. That successor trustee is automatically going to be vested with authority to distribute the trust or administer the trust however they need to. And there's privacy with that. So the only interested parties are going to be beneficiaries, creditors, if any. So there's not going to be any public record of that trust. Couple things to keep in mind, and we're going to touch on these a little bit more in depth, but ownership and beneficiary designations are really important. How assets are owned, if assets are owned jointly, if assets list beneficiary designations, transfer on death designations, payable on death designations, those are going to take precedence over what a planning document says. So we want to make sure that all of the assets are aligned with the plan, and that's a part of what we do in the estate planning process. We also want to make sure that when there's changes in life circumstances, we are appropriately planning for those, making the changes that are necessary. Okay, one of the other things we'll probably get into is estate taxes potentially. And when we talk about estate taxes, we talk about the gross taxable estate, and what makes up the gross taxable estate when somebody dies is all of the assets that they own. That being said, when we talk about estate assets, we talk about non-probate assets versus probate assets. So on this side of the chart here, the probate assets are going to be the assets that are owned only in the deceased individual's name. So those don't have joint owners, they don't have beneficiaries, just the decedent's name. Okay, those are going to be controlled by that court process, either by the will or by the state statutes if there is no will, and those heirs at law or beneficiaries are going to inherit those assets. Our non-probate assets are made up of joint ownership assets, beneficiary designations, payable on death, transfer on death, and trust assets. So as you can see in the chart, the joint owner is going to automatically own an asset if somebody dies. Beneficiary would inherit, excuse me. And then trust beneficiaries are going to inherit the trust assets. So that is a very brief summary of estate planning with wills and trusts. But that gets us into our first scenario here, which is called the haunting of the hidden heir. And on this one, we have Kim, who's come into the office, and I ask him to unmute and tell us a little bit, Kim, about what we can try to help you with.
Good morning. My father passed away recently, and all of his assets were jointly owned with his second wife. Now she has an estate plan that leaves everything to her son. What happens to my dad's assets when she dies, I'm sorry. Will I receive anything?
Well, thank you, Kim, for coming in to see us. I'm sorry to hear about your dad. Unfortunately, this is a common scenario with a second spouse. Most husbands and wives own assets jointly, intentionally, and it provides convenience for that surviving spouse. But what it doesn't do is it doesn't provide for children from a previous relationship or a previous marriage. If all of your dad's assets were owned jointly with his second wife, by way of right of survivorship, she is now going to be the sole owner of those assets. When the second spouse passes away, those assets would then be distributed according to her estate plan or her beneficiary designation. So unless that second spouse is providing for you within their will or beneficiary designation, then you may not receive anything of your dad's estate.
So it's an unfortunate situation, Michael, but if Kim's dad would have come to you while he was still alive, what would you have suggested for him as far as estate planning? I mean, what options would have been available to him?
So I think a couple things would be important is look at the accounts that dad has. And if dad wanted to leave cash bequest to somebody and own that account individually and listed you, Kim, as the beneficiary of that account, then you would have received that asset. We would have looked at all of dad's assets and how they were owned. And if any of them were not jointly owned with his new spouse, then we could provide a designation on where that asset would go at dad's death. Dad also could have had a premarital agreement before his second marriage, and that premarital agreement could have provided for certain protections for children from previous relationships, such as you, Kim.
So that premarital agreement, if they would have entered into that, could that have protected some of those assets against like a will contest also?
Yeah, typically in a premarital agreement, these contemplated spouses are going to waive their rights that they would have as a surviving spouse. One of those rights that a surviving spouse has is a spousal award claim. So even if dad had a will and left everything to Kim, the surviving spouse could have elected against the will and made a claim for a spousal award. That premarital agreement's going to waive or give up those rights between the spouses so that that scenario wouldn't happen. With that premarital agreement, you disclose all the assets that you have to each other. And then at the same time, you make sure that beneficiary designations are set up correctly on individually owned assets. And if you do want to jointly own assets with that new spouse, then you certainly can, but it doesn't default. Everything is owned jointly, as is the situation with Kim's dad.
So the spouse is going to be entitled to something, even if the will says otherwise.
Unless dad would have set up a trust ahead of time. So if dad would have set up a trust and funded that trust correctly, then those assets in the trust could distribute to a beneficiary. It could distribute income to his surviving spouse, with the surviving spouse's death being the triggering event for those assets to go down the line to Kim. And that surviving spouse would not be able to make an election against a trust document in the same manner that he or she could under a will.
So it sounds like maybe that trust would have been a way to provide some income or a living arrangement for the surviving spouse, but also to get the assets down to dad's child or children.
Yeah, and I think even going further, if they own a house together and dad wanted to make sure that his spouse had somewhere to live, he could provide a life estate in that piece of real estate so the surviving spouse had somewhere to live. And at the surviving spouse death, or when the surviving spouse wants to move, then that house could be sold with the proceeds going to the kids.
Okay. Well, Kim, sorry that you're having to deal with that, but thanks for coming in today, and hopefully things work out.
Thank you for the information.
So in our second scenario here, we have the custody curse, and we have Julie here with us, I believe, to give us some information. Julie, how can we try to help you today? Oh, I've got to unmute you first. There we go.
Thank you for having me. My sister, a single mother of 2 young children, recently passed away unexpectedly. The children's father has got a drug addiction issue, and I worry that he will become the manager of the children and their assets. So that's what I wanted to talk about, because I would like to become the guardian and manage their assets for them.
So Julie, this is not a good situation. Without an estate plan, the court typically appoints the surviving parent as the guardian of the children and their assets, even if that parent is not the best choice. This can lead to a prolonged legal battle and significant financial strain.
So the biological parent is a default, right?
Courts will favor the biological parent unless they have good reason to do otherwise.
So tell me a little bit about good reason. If Julie wanted to try to pursue removing the biological father as the guardian of the children, what would that look like?
Well, first you would have to file a petition with a family court. This petition would need to present a case for why the biological parent should be removed as the child's guardian. Grounds for removal can include abuse and neglect, abandonment, criminal behavior, or parental incompetence. Incompetence could consist of mental health issues or substance abuse issues, as we see here. Documented abuse or incompetence are significant grounds for removing a parent as guardian. Courts will look for evidence, such as reports from child welfare agencies, police, or healthcare providers when considering these factors. The court will usually order an investigation, which would involve social services, and a guardian ad litem, which is a court-appointed advocate for the child. That investigation would assess the child's situation and determine the impact of the parent's behavior on the child. Then there would be at least one hearing where all parties would present evidence and arguments to support or contest that petition. The court will evaluate all evidence to decide if the parent should be removed as guardian. If the court finds that the parent is unfit and removes that parent as guardian, it will then appoint a new guardian for the child.
So that sounds like a lot, but if maybe this scenario would have come up before the tragic death of Julie's sister, would a trust potentially have assisted in this situation?
So a trust can be an effective tool for protecting a minor's inherited assets. It can ensure that the child's financial well-being is safeguarded and that the inherited assets are used in a way that serves the child's best interest. By naming an independent trustee to manage trust assets, a trust will ensure that control over the assets is removed from an unfit parent. A trustee is legally bound to act in the best interest of the child and must follow the terms of the trust rather than the desires of any parent. A trustee has full discretion over distributions, meaning they can withhold funds from the parent if it's suspected that that parent may misuse those funds. A trust can include specific terms that limit when and how assets are distributed to support a minor child and specify purposes for those distributions, such as education or medical expenses or living expenses. And the trustee can be directed to make payments directly to a third party, like a school or a healthcare provider, bypassing an unfit parent.
So if a minor inherits assets in this situation, sounds like outright, they would be entitled to have those assets paid to them directly when they turn 18. Is that the way that works?
That's correct. When a minor reaches 18, they're legally entitled to full control of their inheritance. At that point, a guardianship officially ends, and the court initiates a process of transferring those assets to the new adult. Before releasing control, the court often requires a guardian to provide a financial accounting, and that would detail how funds were used and managed. Once the final accounting is approved, the court issues an order allowing the guardian to transfer the remaining assets to the young adult. The funds will be transferred directly to the new adult's bank account, giving them full legal authority over their inheritance. In some cases, if the child's deemed particularly vulnerable or lacks financial maturity, the family may request additional support from the court, such as setting up a conservatorship to continue managing those assets.
Could a trust, if appropriately done, direct the trustee to hold those assets longer than age 18?
Yes, a trust can specify an age at which the child will receive full control. Often a milestone age, such as 21, 25, or 30 is chosen. Until that age, the trustee will continue to manage the assets, making distributions according to the trust terms for the child's benefit. Educational expenses, healthcare, living expenses. Some trusts allow for a staggered distribution where the child would receive a portion of the inheritance at one age and the remainder at an older age, such as half at 25, half at 30. A setup like this will help the beneficiary gradually learn financial management skills. In a discretionary type trust, the trustee has full discretion over when and how much to distribute, rather than having to adhere to specific ages. These types of trusts are often used when the trust creator has concerns about financial responsibility or outside influences. And this gives the trustee a lot of control over the timing and purpose of distributions. And I would say, in general, you want to sweat before the battle rather than bleed during it. Using trusts or other estate planning tools can prevent some undesirable scenarios. And here at Woods and Bates, we're here to help you to prepare to avoid some of these situations.
That sounds like it would be, Julie, maybe a good avenue to pursue if you're able to win that uphill battle of getting guardianship of the minors, and we'd be happy to help you with that. So appreciate you coming in today.
Thank you for the information. I appreciate your assistance today.
So that's going to take us to our third scenario here. We have Beatrice in the office this morning.
Hello,
Love the name, by the way. It's a great name.
thank you. Thank you for meeting with me today. I'm here because my sister Samantha Locke passed away, and she was a very private person with a substantial amount of wealth. She had no spouse and no children, and we have been estranged, unfortunately, for quite some time. I found that she had handwritten a will that left all of her assets to her alma mater, but I also noticed that it wasn't witnessed. I'm wondering if that will is valid, and if not, as her only heir now, can I assume that I will be receiving all of her assets under Illinois law, even though that's not what she wanted?
Well, I'm sorry to hear about your sister, Beatrice. Sounds like you have a pretty good understanding of how Illinois law works. Maybe you have worked at a law firm for a long time and have dealt with these things in the past. But you're absolutely right. A will that is not witnessed by somebody is invalid. There's no prohibition on drafting what's called a holographic will in Illinois, meaning you can handwrite your will and leave your assets and nominate an executor as you desire. But that document needs to be witnessed by two unrelated adults. And if it's not, then it's invalid, as if that document doesn't exist. And this scenario really highlights the importance that you and anybody ensures that your estate planning documents not only say what you want them to do, but also are executed in compliance with Illinois law. Without a will, you're absolutely right. The heirs at law intestate would inherit. And under this scenario, with Samantha not having a spouse or children, and if your parents are passed away, then you are the sole heir at law. And that bequest that Samantha wanted to make to her former university, unfortunately, won't be followed.
So it sounds like formalities seem to be pretty important. What steps do you typically take, Michael, to make sure that the formalities are met and that the documents are legally enforceable and binding and are not going to be void, as in this situation?
Well, one thing we do here is when we draft estate planning documents, well over 95% of the time, the clients come into the office, they meet with our team, and they sign those documents here in the office to ensure that they're executed correctly, that maybe a signature line wasn't missed, the appropriate number of witnesses, or if a notary is required, those individuals come in here and we hold their hand through executing the documents. In the rare situation that we prepare estate planning documents and send them out to the client for signature on their own, which happened a lot during the COVID time period, we will give a detailed memo and instructions on how to execute those documents correctly so that they are valid. Other than the actual signing and witnessing of documents, when you meet with somebody here at our office, we ensure that other reasons for invalidating the will are taken care of. So some other reasons to invalidate a will would be uh, the person lacked the capacity to execute a will. And so there's a really low threshold in Illinois to have mental capacity to execute a will. But when we meet with people to sign, we make sure that they have that capacity. Another reason why your will could be invalidated is if you are signing under duress, or if somebody has unduly influenced you to leave your assets to somebody to the exclusion of maybe another equal beneficiary. So we go over a script of questions with each client that signs their documents to ensure that they have the capacity, that they aren't acting under duress, that they know what they're signing and they're disposing their assets according to a plan, and that no one is unduly influencing them. Uh, Clients will come in and they'll have their children with them, and whenever we have the signing appointment, those children are left out in the lobby. There's no one else in the room whenever those documents are signed, to ensure that there is not that influence on the person executing the documents.
That's good. For the benefit of our malpractice insurers, we do not physically hold their hand. That's a figure of speech that Michael was using. But the process is really important. You know, the formalities and the legalities are really important to make sure that those documents do what they're supposed to do. So it sounds like to me, you know, maybe Beatrice, if you wanted to do some estate planning, perhaps you're going to get a windfall here, but you could make some gifts to your sister's alma mater if that's what you want to ultimately happen, and we can certainly help with that.
Thank you. I appreciate that.
So thanks for coming in this morning. Michael and Brett, thank you for going through our scenarios with us. I just have a few more closing thoughts, I guess. When we're doing estate planning, the things that we want to discuss, the things we want to talk with clients about, and we want clients to be thinking about when they're drafting estate planning documents are, there's a whole laundry list of them, but just a few of them are, do we need to be thinking about limiting estate taxes? The way we do this is compile a list of assets. We look at how those assets are owned. Are there beneficiaries listed? Are those the beneficiaries we want to be listed? Where do we want the assets to go? Who do we want them to go to? What entities? You know, in one of these scenarios, do we need to protect heirs from themselves? We had a biological parent with some drug addiction issues. Do we have children that have drug addiction issues or substance abuse issues? Do we have children that are spendthrifts? Do we have, you know, beneficiaries that are going to need help along the way? Then who do we want to be acting as our executors, as our trustees, as our agents, as our guardians? And if those people can't act, you know, who do we want to act? A lot of times people are nominating somebody that's very close to them. You know, for obvious reasons, we want to be able to trust that we're nominating the best possible people, but those are the people that are normally doing things like traveling with you in the same vehicle with you. So we want to make sure that in the event they're not available, we have somebody else in line to take action as necessary. Who do we want to care for our minor children if we have them? Again, who's the successor guardian? Do I need to be thinking about creating a trust? You know, who do I want to act as the trustee? Do I want to make any specific gifts of property? And if so, those need to be outlined in the planning document as well. So those are several of the things we discuss when we're doing estate planning. We're assisting with estate planning with clients. Here's just a real brief scenario of cost of planning versus failing to plan. So if you have a situation where there's a potentially taxable estate, and the numbers right now in Illinois, there's a state estate tax for estates that are over $4 million in value. That estate tax is regressive, so it goes down. It's kind of goofy, but the federal estate tax exemption amount right now is 13.61 million, and that tax rate is very punitive. The federal estate tax exemption amount is set to go down if nothing happens in Congress, which it doesn't seem to ever happen anymore. That'll go down to about 7 million per person. So I would estimate that on estates like this, your cost of planning is going to be somewhere around $3,000 to $10,000 to come up with a plan that's going to try to eliminate tax as much as possible, and get your assets where you want them to go. If there was not sufficient planning, a estate tax on an Illinois estate of $5 million is going to be about $285,000. The estate tax on an $8 million estate in Illinois is going to be about $680,000. And so, you know, just rough numbers, if we have a married couple that has $10 million in total assets with appropriate planning, we would suggest that we could probably get that tax down to zero. So as you can see, there is a significant savings potential for those that do some planning, and the cost to do it is relatively low compared to the benefit to the beneficiaries. Obviously, the person that died is not going to benefit from that tax savings, but the beneficiaries, the people that they assumedly care about, are going to benefit greatly. So if we don't plan, there's going to certainly be some consequences of doing that. And we also, you know, it's worth mentioning, need to make sure that that plan is maintained, that it is still current, that it's still what we want. So everyone's circumstances are different. We believe that estate plans need to be specifically tailored by the attorney and the client, with the client's input, to make sure that we're accomplishing the client's goals. These are not our goals. We can make some suggested goals, but, you know, if you don't care about saving estate tax, that shouldn't be a part of the plan. The estate plans should be reviewed, revised to remain current. We do offer what we call the client care program, which is an annual program that we offer to our clients, where we want them to come in annually at least and review their plans, make sure there hasn't been life changes, you know, deaths, births, divorces, adoptions. Those annual type meetings make it a lot easier to make sure that that plan is going to be current and reflect current law. Believe that everyone should make their wishes known while they're living. I think that this avoids confusion, it avoids feuding, and confusion and feuding equal litigation and lawyer fees. So we want to avoid that too, if at all possible. With that, we would be happy to schedule time to discuss with anyone that wants to. We just need to know how to contact you. We can sit you into a separate room with one of people on this call. Stop sharing my screen here. If you so desire, and you know, we have some time here. If anybody does have any questions, just, I think you can unmute yourself. If not, raise your hand, I'll unmute you. Other than that, thank you for coming, and we hope to hear from you soon, and everybody have a happy Halloween.
So Blinn, there was a question in the chat. Sean asked, what roughly causes the cost range to be on upper or lower end? And so I think first and foremost, it depends on the complexity of the assets, whether or not somebody has an estate tax issue. Your lower end price range is looking at someone that doesn't have a complex makeup of assets, does not have an estate tax issue. And then the higher end of the cost range would be for somebody that has a variety of different assets and also an estate tax problem. There's a lot of complexity involved with the planning there, which then causes that price to go up.
I agree with that. Did anybody else have any questions? Got the chat up now, so I can see those too if you want to put them in there.
Julie, did you have your niece or nephew there with you?
Yes, I did. He's a little stinker.
Julie's changing her mind about getting guardianship.
I think that's a good reminder that everybody that you nominate for these different fiduciary roles, whether that's an executor, trustee, guardian, you want to make sure that that person's willing to do it, because they have the right to act as those roles, but they have no obligation. So Julie, if your sister nominated you as the guardian and you knew that Julie's kids were ornery and you wanted nothing to do with it, you have no obligation to accept that nomination. So we like to do more of a family planning aspect when we meet with clients, ensure that the individuals they're nominating are willing and able to take on those roles when the time comes.
Sure.
All right. Well, unless anybody has any other questions, there's one in there. Firm have experience with special needs trust planning. We do. We do that. And that is important. Someone that has special needs is going to probably need trust planning. And there's different laws that apply to that type of planning, especially in the case of somebody that's receiving governmental type benefits, because you don't want to have that individual receive a large inheritance, or any inheritance really, that's going to negate or disqualify them from the governmental benefits. So that type of planning is really important if there is somebody beneficiary that has special needs, and we can certainly help with that. It's a question about land trust transfer to irrevocable trust with multiple beneficiaries of original land trust itself. That's probably something that we could look at. I don't know the specifics, but I think that's probably something that we would need to sit down and have an appointment and look at those particular documents to see what they say and who the players are and what needs to happen. A lot of those are very specific on, who can do what and how they work. The parent has their house as an asset. Would a will or trust be best for Medicaid protection? So Medicaid protection is probably a seminar in and of itself. When you're trying to do Medicaid planning, it's likely that a trust is going to be necessary to try to protect that asset. That's going to be more along the lines of a irrevocable Medicaid protection type trust. But there are a lot of specifics that go into that, and there's look back periods, and you have to make sure that you're not violating those, and it's not an emergency situation that you're creating more of a problem than you started with. So again, that's a unique planning aspect, but that is something that we could assist with if you wanted to sit down and have that discussion.
Typically somebody's home is considered an exempt, and that's a subjective test. So there's some different type of planning that goes in to ensure that that individual has that intention to move home. But typically that primary residence is excluded as an available resource for Medicaid purposes. Not always, but most of the time.
All right. Well, I've got some pups that need to get let out, so I'm going to shut it down. If you need to make an appointment or want to make an appointment, we are happy to do that. Our phone number is 217-735-1234. Thanks again for joining us, and take care.